in Asia, I think Singapore has been the leading jurisdiction in terms of sort of signing up to the convention and actually implementing it. Now, for those of us here, you may know the convention came into force in Singapore on the 1st of October 2016. The relevant enabling legislation, being the Choice of Court Agreement Act, was passed in April that year. So it's been around now for a little bit of time. And, quite positively, we've begun to see judgments coming out of the courts that actually are dealing with it in a positive way and in an enabling way as well. We heard about the first decision that came out in 2018. It's the decision of Jason versus SynCap Financials 2018. Again, this was a decision of the assistant registrar, but concerned an application by a plaintiff seeking the recognition and enforcement of a summary judgment from the High Court of England in Singapore. And again, the court did take a lot of pain to go through the relevant provisions of the convention, the relevant provisions of the local legislation, and decided that there was basis for the application to be granted. And it's a good example, I suppose, or in fact, we've heard the first example, of the convention actually operating in practice through the courts. And allowing parties, as Anselmo said, the clarity and the simplicity of being enabled to enforce a national court judgment in the territory of another contracting state. So again, upholding the objectives. We had another more sort of recent decision just last year in 2021, the decision of 60M versus AE Brands Korea, again, a decision of a High Court judge. This concerned, whether an exclusive jurisdiction clause in favor of the English courts existed. So the court was considering whether the clause it was actually an exclusive jurisdiction clause such that the Singapore courts must actually decline to exercise jurisdiction. Now, you will remember in my introduction, I said, one of the elements of the convention is not only does a court have to hear a dispute, but if you're a court that is faced with a clause that doesn't involve your court, then you're obliged to actually decline jurisdiction. And this is what the Singapore court had to face. The court eventually found that the clauses in questions were in fact exclusive jurisdiction clauses in favor of the English courts, and that none of the exceptions that potentially allowed them to do otherwise would allow the Singapore courts to hear the matter. So they were not going to hear it. Now, I suppose what is significant, apart from the fact that, again, it's another decision upholding the effect of the convention and showing Singapore's resolve to sort of keep to the deal that it signed up to, was that in interpreting the provisions of the local Singapore Choice of Court Agreement Act of 2016, the court actually placed a great amount of weight on the fact that the act was based on the Hague Convention. It relies significantly on the explanatory report of the 2005 convention in interpreting the legislation here in terms of giving the effect to it and the objectives behind why the provisions were the way they were. And you can see this in paragraphs 27, 28, 37, 56, 60 of the judgment. So it does really demonstrate, at least on the part of Singapore, a serious intention. And again, as Anselmo said, it sort of reinforces that signal to the world that, look, we are willing to give you that certainty in business, right? So if you're coming to have your disputes adjudicated in Singapore, choosing the Singapore courts, doing business with us, then this is a jurisdiction that will be stable and will uphold its obligations.